Hi, everyone. Welcome to Helping Clients Access Gender-Affirming Care, information for legal services attorneys in California. Before we get started, we want to mention a few logistical notes. In order to turn on live captions, press the button with the CC symbol below. This session will be recorded and uploaded to the LAC website within 1 week of the event, and you will be receiving your MCLE certificate within 1 week of the event. This training is eligible for 1 hour of general MCLE credit. Please feel free to use the Q&A function to ask your questions. Thank you. I'll hand it over.
Hi, everybody. My name is Lori Rifkin. I'm the litigation director at Impact Fund, and I am moderating this panel of experts. And the reason we wanted to put this panel on is that there's been so much happening on a federal executive order level with rumors about what health regulations are going to pass, subpoenas, so much swirling in the air that it's really hard to tell what end is up as far as provision and access of gender-affirming care in California, where we do have a lot of protections. And so we wanted to hold this training to help everyone, especially all of you who are regularly interacting with clients, get a better sense of the legal landscape and where to go for more information. And so with that, I will turn it over to Antonio.
Rookie mistake. Good morning. My name is Antonio Page Khan, he, him, his. I'm a lead attorney with the Legal Aid Society of San Diego. We're very thankful for you all attending today's webinar. We're also thankful for Lori and Impact Fund, as well as Legal Aid Association of California for coordinating this. We're going to go ahead and start off today with 3 poll questions just to gauge a little bit of information about you all. We'll start with the first one. It should pop up momentarily. And it is, do you have experience serving the transgender, gender diverse, and intersex community? The first is, yes, I am very experienced serving the community. Yes, but only a few times. Yes, but only one time. Or no, you don't have any experience serving the TGI community. And we will give it a second. It doesn't tell me how many individuals have finished, so I think we can go ahead and move on to the second question. Or does it give us results right away?
It says about 83% of people have answered so far,
Okay.
but we can move on if you'd like.
Yeah, let's move on to the next one. Oh, wonderful. It looks like we have a big swath of individuals with experience. So great to hear. This will be a really helpful overview today then. For those of you who have less experience with the community, we won't be spending as much time on terminology. So if you do have questions, there are plenty of resources packed within the slides that we'll be sending afterwards. And also, we have our contact information, so please don't hesitate to reach out if you have follow-up questions. And we can go to the second poll question. Do you have experience with cases involving barriers to gender affirming care? Yes, you're very experienced. Yes, but you have limited experience with few cases. No, you have no experience, but you want to gain the experience. And we'll just do a couple seconds to save us time. 5, 3, 2, okay. Let's see the results. No experience. Wonderful. Well, we're super happy you're here today, and hopefully today provides you a good first place, at least where the resources are, and a general overview. Let's do the last poll question, please. Do you currently have any cases involving barriers to gender affirming care? Yes, you have 4 or more cases. Yes, you have 1 to 3 cases. No, you don't have any cases. And we'll just go quick. 4, 3, 2, and we can close out this question as well. Okay, wonderful. And I think that's an expected answer after the second one. So let's go ahead and get started with the next slide, please. So we're all, the three of us are part of different firms. Liza, Abby, and I are all different firms throughout the state, but we are members of the Health Consumer Alliance, which is 10 different legal aid programs throughout the state. Geographically, we cover the state in its entirety. So I am from Legal Aid Society of San Diego. San Diego is one of the biggest counties, so we only serve San Diego County, except for some rare exceptions. Liza, for example, is Legal Services of Northern California, and I believe she has it's upwards of like 10 to 15 counties, I believe, that they serve. But no matter where you are, we have someone to help you. Our services are free, and if you do need assistance, you can go ahead and go to our website, or if you call the phone number on there, it will, 32, Liza has 32 counties, someone corrected me. But if you call that number, it will direct you to your appropriate HCA firm. So you don't have to worry about, which county, who serves which county, it'll do that automatically. Next slide, please. Okay, so general overview of what we'll be doing today, level setting. We're going to do, some gender affirming care 101, just to get a general understanding of an overview of what gender affirming care is. Abby will take us into legal protections for gender identity and gender affirming care, and we will move into Liza with insurance regulations. We're going to do an overview of the current federal threats and actions, how that appears in your casework in California, and issue spotting. Liza will then show you ways of how to find these cases when you're doing other cases such as employment or public benefits. Next slide, please. Next one, please. Okay, so I'm not going to go over all of these terms, but I will touch on a few of them. Gender dysphoria speaks to when a person experiences significant distress and discomfort due to a mismatch between their body's physical presentation and their gender identity. Now, not all transgender individuals or gender diverse individuals experience that distress to a level where they seek surgery, right? So the general rule of thumb is just don't assume. Don't assume someone's identity. Don't assume the services that they want to seek, or that there are certain services you must receive before you can call yourself transgender. And I give it a description. Okay. Apologies for low vision. So perhaps read the title at least if you can. Okay, I apologize. I will begin reading the titles for those of us who have low vision. Transgender, gender diverse, and intersex is kind of the broad umbrella term we'll be using today to speak about the community. They all have distinct identities. The general rule of thumb is however someone self-identifies is how we should identify them, right? A transgender person, the description here is a person whose gender identity does not align with the sex that they were assigned at birth. But if someone identifies as transgender, you don't need to go into asking them, oh, does your gender identity align with your sex assigned at birth in order to call you transgender, right? We're deferring to the clients and how they identify themselves. And when I do these presentations, I always think about my dad who, grew up in a different time. And one thing he always complains about is LGBTQIA+. There's so many letters now in the alphabet soup. How am I supposed to keep up, right? Well, one, you can always ask how someone identifies is the easiest way, right? We don't expect everyone to know everything. But two, all of those letters actually represent our existence throughout history and through different cultures, right? It's just now that we are being able to identify them and speak about them and refer to each other. So, for example, the Kingdom of Hawaii has Mahu individuals, which is the third gender category that isn't male or female. And it's kind of somewhere in between, and they see them as healers or someone who's within the field of medicine, or they used to bless the wedding ceremonies. You have the Hydras in Southeast Asia. You have their history even goes back to gender neutral deities within the Aztec and Inca empire. So, we have been around. There are a lot of identities that you're not expected to know all of them. So always defer to what the client refers to themselves as. Will you go to the next slide, please? For gender affirming care, gender affirming care is a patient-centered healthcare that may include a wide range of interventions that help people align with their gender identity, with their physical traits. Like I said earlier, it's not a one size fit all. Not everyone needs surgery or wants surgery or seeks surgery or hormone therapy or mental health services. The most common used standards of care is published by, we refer to them as WPATH, but the World Profession Association of Transgender Health. And you can certainly, it should be linked in the slides as a resource as well if you want to take a look at it, but it also provides great information if you're working these cases and understanding the standards of care. Next slide, please. For surgical procedures and treatment, they can be sex reassignment surgery, facial gender confirmation surgery, body contouring, hair removal, and vocal surgery. Sometimes clients will refer to surgeries differently, right? Depending on how they even refer to their body. Sometimes it could be top surgery, bottom surgery. My best advice to you is to follow the language of your client, right? If they are saying, oh, I want surgery to remove my breasts, then respect the language that they're using. Some individuals may say, I want surgery for my chest, right? Well, then you don't start saying breast if they say chest. So, rule of thumb, if you're new to these cases, don't assume, right? And always ask. And I will pass it on to Abby for the next portion.
Thanks, Antonio. So my name is Abby, and I'm going to talk a little bit about some of the legal protections that are available to TGI people who are seeking gender-affirming care in California. Next slide. So to start with the federal protections, I'll go over a couple of the big ones, and then as you'll see at the bottom of the slide, there are any number of other federal laws that may apply depending on the specific issue or the type of plan, and Liza is going to get more into some of those nuances a little later. So that's just a preview. But to start off, the two big federal protections that we think of when we think about access to gender-affirming care, one is constitutional equal protection. As you probably remember from a common law class, those of you who went to law school, that applies to state and local governments as well as government officials, and it protects against discrimination based on sex. In some jurisdictions, including here in the Ninth Circuit so far, it may also provide protection against discrimination based on transgender status or gender identity. That said, you may have heard in the news, really big equal protection lawsuit decision handed down by the Supreme Court earlier this year called Scrimetti. And we'll talk about that a little bit more in a bit, but in short, that the Supreme Court held in that case that Tennessee's ban on gender-affirming care for minors did not discriminate based on sex or transgender status. So a little bit of a question about what equal protection is going to look like in these cases going forward. The other big federal protection is from the Affordable Care Act, what is called Section 1557 of the Affordable Care Act, or the non-discrimination provision of the Affordable Care Act. And this provision applies to most healthcare, or to all healthcare entities that receive federal funding. So that is going to extend to most providers and most health plans because they almost always get some form of federal funding. The Affordable Care Act specifically prohibits discrimination based on sex by those entities. And indeed, several courts have relied on that provision to strike down limits and bans on gender-affirming care. So that is a good federal protection to look at. As I said earlier, any number of other laws that may apply, including ERISA, the Federal Medicaid Act, Federal Medicare Act, the Americans with Disabilities Act, but that's going to be more of a case-by-case inquiry as to whether any of those other protections apply. Next slide. Here in California, we also have some really great protections in our state law. So we have some general non-discrimination protections. These are not healthcare specific, but California prohibits businesses, which includes nonprofits and healthcare providers, as well as government entities, from discriminating on the basis of sex, gender identity, gender expression, sexual orientation, and transgender status. And they also bar discrimination based on perceived sexual orientation or gender identity or relationship to someone who is LGBTQ+. And there are citations on the slide. As Antonio said, you'll get the slides later with all of those citations to the various statutory provisions and a recent letter from the Attorney General that also kind of fleshes out these protections in a little more detail. Next slide. In California state law, we also have a specific affirmation of the right to gender-affirming care. So the Civil Code at 1798.301 states, reproductive health care services, gender-affirming health care services, and gender-affirming mental health care services are rights secured by the Constitution and laws of California. Interference with these rights, whether or not under color of law, is against the public policy of California. So a very broad statement to protect access to gender-affirming care in our state. Next slide. We also have various state laws that ensure the right to gender-affirming care specifically. Again, Liza is going to go into some of the nuances about how to determine which of these laws applies in a particular situation. But for plans licensed by the Department of Managed Healthcare, you can see the citations that provide those protections. For plans licensed by the California Department of Insurance, a separate set of laws and regulations that apply. And then for people in Medi-Cal, our healthcare program for low-income people, a series of citations on the protections that apply there. But in short, if you are in a plan or healthcare program that is governed by the state of California, there are protections for gender-affirming care. Next slide. We also have a whole laundry list of laws that are intended to protect people who have accessed gender-affirming care and their providers. So, specifically trying to protect people here from prosecution by other states or the release of medical information when it is requested pursuant to another state's law that bans gender-affirming care. And again, I'm not going to read all of the citations, but you'll have them in the slides. And I'll note that some of these statutory provisions have just been updated in the most recent legislative session. I believe some of those changes went into effect immediately, so just a week or two ago, and some will go into effect January 1st of 2026. Next slide. And now I will turn it over to Liza to talk about why this is all so complicated.
All right, I'm going to talk about insurance regulation. Next slide, please. So kind of the insurance regulation can be pretty complicated, but for purposes of this webinar, I'm going to try to focus in on like more big picture stuff. So as Abby just mentioned, there's clear strong protections for gender affirming care and gender identity in California law, and where the law is less strong is in federal law, right? So really the thing that you need to look at the most when you're advising a client on what their protections and rights to gender affirming care are is whether federal law applies or whether California law applies. And my big takeaway is that there are many people who live in California who have health plans that are not regulated within California. So they're not subject to California law, which means that you don't have those strong legal protections that Abby just talked about. And so that is where you really have to kind of go into the nitty gritty in talking to your client about what their access to gender affirming care might look like. Next slide, please. Okay, so like I said, insurance regulation can be really complicated. My big takeaway messages are that people should not make assumptions without enough information. Generally, you need to know the payer, the health plan, and the delivery system in order to correctly identify the applicable laws and the relevant regulator for a specific health insurance. That means not just knowing that it's Medi-Cal, but also knowing that it's Anthem Blue Cross versus partnership, right? That will lead you to different laws, different regulations, different regulators. So, a lot of times clients will tell you like, I have Anthem Blue Cross, and that's not enough information to determine what laws apply to that plan, because Anthem Blue Cross, it really could be anything. It could be a Medicare plan, it could be a Medi-Cal plan, it could be private health insurance, it could be an HMO, it could be a PPO, and all of those sort of combinations of different things will lead you to different applicable laws and a different regulator. So people really should not make assumptions about what their protections are, like one way or the other, of like, oh, I'm safe, I have Anthem Blue Cross, right? Like, or I'm not safe, I have Anthem Blue Cross. People shouldn't make assumptions. And really, like, my messaging to our client community is really, if folks have questions or concerns about their access to gender affirming care, they should seek out an individualized legal consult. So really, please call legal aid, and we can tell you exactly what your rights are. And because it will be different for everyone, even people living in the same household within California can have, different applicable laws for their health insurance plans. Okay, next slide, please. So this is just an example of how the different combinations of payer, health plan, and delivery system can lead you to different laws and different regulators. So for example, Anthem Blue Cross, if it's an HMO, it's regulated by the California Department of Managed Healthcare. The relevant law is in the Health and Safety Code. If it's an EPO, though, it's regulated by the California Department of Insurance, and the relevant law is the Insurance Code. This is like kind of oversimplifying it a little bit, honestly, but this is an example of why you have to know quite a bit more detail about the type of health insurance it is before you can make a determination of what law applies. And unfortunately, a lot of times consumers don't know, right? Like you ask someone, what kind of health insurance do you have? And they'll say, I have Anthem Blue Cross. But like I said, Anthem Blue Cross could be anything. It could be Covered California, it could be Medi-Cal, it could be Medicare, it could be an employer plan. So many different possibilities for what law would be applicable to that specific Anthem Blue Cross plan. Next slide, please. This is another example. If you have an Anthem Blue Cross and it's an HMO, that could be a Medicare plan or it could be a Covered California plan. And if you don't know, if all you know is Anthem Blue Cross, it's an HMO, that's not enough information to determine what law applies. So here it really makes a difference, because if it's a Medicare Anthem Blue Cross plan, then it's regulated by CMS, which is a federal agency, and the relevant law is federal law. It doesn't have to comply with California law. But if it's a Covered California Anthem Blue Cross HMO plan, then it is regulated by California law. It'd be regulated by DMHC, and you'd have all the relevant California law that Abby just talked about. So this is where it makes a huge difference, especially when we're talking about gender affirming care. So within California law, there's many different sources of relevant law, different regulators, but we're not going to really go into that today because that would take way too much time. So kind of for the purposes of determining the rights for gender affirming care, like the big picture first sort you need to do is it federal law or is it California law? So next slide, please. So just really quickly, I'm going to cover just like the most common insurance types that we see at legal aid. So Medi-Cal obviously is the one that we see the most often. It's California's Medicaid program for low-income people. And then Medicare, it's a federal program for seniors and people with disabilities, federal being like the operative word there. And then we see a lot of Covered California plans which are private insurance through California's marketplace. And then employer insurance is kind of the last big bucket of health plans that we see. And that is where things get really tricky. So next slide, please. So again, like I said, the big picture sort you need to do is, does California law apply? So in Medi-Cal, California law is going to apply in all Medi-Cal plans, fee-for-service Medi-Cal. So any Medi-Cal, California law will apply. There's different sources of law and different regulators depending on which type of Medi-Cal plan it is. But again, we're not going to go into that today. Just know that if it's Medi-Cal, California law will apply in some way, shape, or form. The next one, Medicare, like I said, it's a federal health program. California law does not apply to that. So it doesn't matter if it's original Medicare, if it's a Medicare Advantage plan, you don't have the protections of California law there. The next one is Covered California. So Covered California, all of the health plans that participate in Covered California, California law is going to apply. So whether it's an EPO or an HMO or a PPO or it's Anthem Blue Cross or Kaiser or whatever, if it's participating in the Covered California marketplace, California law will apply there. And then the last two buckets are employer-sponsored coverage, which is kind of the trickiest one to figure out. So within employer-sponsored plans, like the two types are fully insured plans and self-insured plans. So fully insured plans, you do have California law. Self-insured plans, you don't have California law. But I find consumers almost never know if their employer plan is fully insured or self-insured, and it can be pretty tricky to figure that out. And I'll give you a couple tips on how to do that. Next slide, please. So employer coverage, self-insured or fully insured. So these are like the two tips that I give when you're trying to figure out if a health plan is self-insured or fully insured. My first tip is to ask about the employer. So any very large employer like Walmart, Starbucks, Whole Foods almost certainly will be self-insured, which means that they are federally regulated. There's no California law that's applicable there. Any very small employers are almost certainly fully insured. Obviously, those are like squishy terms, right? And like the employers that are like medium size, it can be hard to tell. Anything that's like really big, like a Walmart or Starbucks, like I said, like that's just very clearly a self-insured plan. And anyone that's got like, under 5-10 employees, like that's very clearly a fully insured plans. And it's kind of like in the middle of like maybe you have a few hundred employees that it's like could go either way. The other tip I have is to look at the back of the member ID card. So ask the client, like, do you have your member ID card? Flip it to the back and look for any language that says something like Anthem Blue Cross provides administrative claims payment services only and does not assume any financial risk or obligation with respect to claims, or something like Anthem Blue Cross is a third-party administrator only. So that kind of language signifies that it is a self-insured plan, which means federal law, not California law. And you're going to have a lot harder time enforcing the right to gender affirming care in those plans. So next slide, please. All right, and then hand it back to Abby.
Thanks, Liza. And I realized I didn't introduce myself when I first started talking. I was just so excited to jump in. So hi, everybody. Abby, she, her. I'm a senior attorney with the National Health Law Program based in Los Angeles, and we are also a part of the Health Consumer Alliance. So I have the enviable task about leading you through all of the current threats to access to gender affirming care from the federal level in 10 minutes. So suffice to say, this is going to be a very high level overview. In your materials, you will get a chart that goes through all of this in much more detail. But again, with the caveat that all of this is changing and evolving quickly. So the chart is accurate as of today, but tomorrow things could be different. So we're going in kind of chronological order here, starting with 2 executive orders that were promulgated in January of this year. The first one is 14187, which directed federal agencies to take various actions to limit access to gender affirming care for people under the age of 19. And there was also Executive Order 14168, which sort of set forth our current administration's views on gender and sex. Both of these orders in and of themselves do not have any real legal effect, but they are sort of the catalyst for various actions that federal agencies are taking, as we'll see. And one of those current impacts for people in California, as Liza already previewed, is that people who are enrolled in federal health programs may no longer have coverage of gender affirming care, or in some cases, they will be preparing to lose that coverage as of January 2026. So that is something to keep an eye on. Next slide. A few months later, the Attorney General Pam Bondi issued a memo flowing from those executive orders on, quote, genital mutilation. She put forth her legal opinion about various ways that gender affirming care could be construed to violate existing laws prohibiting genital mutilation. Again, that's just a memo with an opinion. It has no legal effect, so it has no current impact other than the fact that it contributes to a climate of fear and uncertainty about access to gender affirming care. Next slide. I mentioned before Scrimeti, and I'll just note, I think the next 5 or 6 things that I'm going to discuss all happened in June of this year, which, as you may know, is Pride Month. So very discouraging that so many bad things happened this year during Pride Month. The Supreme Court handed down its decision in the Scrimeti case, as I mentioned earlier, holding that 14th equal protection and challenge to a Tennessee law banning gender affirming care for minors, finding that the law was not subject to heightened scrutiny because it only categorized based on age and medical condition, and those are not protected classes. And therefore, 2, the law was constitutional since it was rationally related to protecting children. So a very disappointing Supreme Court decision. And really the impact now is just for those of us who are lawyers, to be careful about asserting a US constitutional equal protection claim to assert the rights of transgender or TGI people in federal courts because the lay of the land is a little trickier now. Next slide. Also in June, sorry, we're missing a B there, but in the One Big Beautiful Bill Act, the government proposed initially to ban funding for gender-affirming care. Well, they actually did two things. They proposed to ban Medicaid funding for gender-affirming care, which could have made gender-affirming care no longer readily available in Medi-Cal, and also they proposed to prohibit gender-affirming care from being included as an essential health benefit, which impacts private plans and especially plans offered through the Marketplace program like Covered California. Now, both of those provisions were rejected. They were not included in the final law, but there was a lot of press and hubbub around the proposal. And so I think there's, again, this contributes to sort of the fear and confusion in the community about whether there is some sort of ban in place and whether people still have access to services. Next slide. One thing that was included in the One Big Beautiful Bill Act was a ban for 1 year of federal Medicaid funds from being used to pay providers, quote, primarily engaged in family planning services, reproductive health, and related medical care, unquote, if those providers also provide abortion. This is what has been commonly referred to as the Planned Parenthood ban, although it also affects other clinics that are similarly situated. And for our community, for when we're looking at access to gender affirming care, a sort of side effect of this funding ban is it's limiting access to providers, since many of these same clinics are also the clinics that provide gender affirming care in our community. Here in California, there are some clinics that have already had to close or limit their hours or services as a result of the funding loss. And this is something that is being actively litigated right now. Next slide. Another thing that happened in June was the Marketplace final rule. The feds issued regulations which prohibit states from covering, quote, sex trait modification, unquote, procedures as an essential health benefit starting next year. Again, what this means for California is if this provision of the law is allowed to stay in effect, and it is subject to litigation right now, California will have to defray the cost of covering certain gender affirming care services for people in covered California. California can and will still require state license plans to cover gender affirming care, but it's really about who has to pay the cost of that care. And that is something, there were provisions for California to pay that cost in the budget that was finalized a couple months ago. So no current impact for people, but something to be aware of. Next slide. Subpoenas to hospitals. So then in July, the US Department of Justice sent subpoenas to approximately 20 hospitals seeking information about those hospitals' provision of gender affirming care to young people, including specific patient and provider details. The impact of those subpoenas is that some hospitals have closed their gender clinics or limited the care they're providing. The list of the hospitals that have received the subpoenas is not public, so we don't exactly know, but our best information is that at least Rady Children's in San Diego, Children's Hospital here in LA, and Stanford up in the Bay Area have received subpoenas. Again, we don't exactly know what information has been divulged by those hospitals to the US Department of Justice. Some hospitals in other states we know are challenging those subpoenas in court. And it is possible that some of the California hospitals are also challenging the subpoenas in court, but those proceedings are typically sealed, which means the information about those cases is not available to the public. So it's been a little bit of a black box. Next slide. Also in July, the Federal Trade Commission held a workshop purportedly seeking information about, quote, unfair or deceptive trade practices, unquote, in the provision of gender affirming care to minors. And that was followed by a request for information seeking public comment on that topic. So no current impact, but this is another signal that this federal agency is looking to do something to make it harder for people to access gender affirming care, again, contributing to the fear and uncertainty that people experience. Next slide. And then two potential rules that I know people are watching closely. The first is the Medicaid funding ban. So in July, the Centers for Medicare and Medicaid Service, CMS, issued notice that it had submitted to the Office of Management and Budget, OMB, a proposed rule titled, quote, Medicaid Program Prohibition on Federal Medicaid Funding for Sex Trait Modification Procedures Furnished to Children and Youth, unquote. So that indicates their intent to put out a proposed rule. A proposed rule would have to be, followed by a notice and comment period, a time for a review of those comments received, and before a final rule could issue. So this is just the first step in what will be a somewhat long process before any final rule would come out. But again, a signal and a concerning signal that I think has people very scared. So no current impact of that, and the process is currently delayed due to the federal government shutdown. So there's unlikely to be any action there until the shutdown ends. Next slide. And then the second rule, a few weeks after that Medicaid rule, and sorry, the title of the slide should say conditions of participation. But so the first rule I mentioned was a ban on Medicaid funding. The second rule that CMS submitted to OMB in August is titled, quote, Medicare and Medicaid programs, hospital conditions of participation, limiting participation based on performance of sex trait modification procedures on children, unquote. So our best understanding is that the intent of that proposed rule would be to give CMS the ability to take away any federal funding, any federal Medicaid or Medicare funding from hospitals that provide any kind of gender affirming care to young people, even if that care is delivered for people who are not enrolled in Medicaid or Medicare. So this rule potentially has a broader reach, and for that reason is particularly scary. But again, all we have right now is a title. No proposed rule is out yet, and will unlikely to be out until after the government shutdown ends. We'll have to go through notice and comment and then a finalization process, and then likely litigation. So much more to come there. Okay, next slide. And I think I'm turning it back over to Antonio now.
Yes, thank you. So a lot is going on that can create confusion. So, I'm sure you're wondering, well, if we are trying to work these cases, how do they appear? How does it arrive on our desk? What do the barriers look like? How is it presenting itself? Well, right now, I think the most calls I get is just pure community confusion and wondering, is gender affirming care still covered? And like Abby has explained and Liza has explained, the short answer is yes for plans that are regulated by California. Obviously, that's a lot more nuanced, and that's a very simplified answer. And then for all other plans, it depends. Federal, less protections. California state, more protections, right? So right now, I think the biggest issue with all of the confusion is that it's causing a lot of timely access issues. It's taking a very, very long time to get any appointments scheduled. Part of it is the inability to find providers, right? And before you can get a surgery scheduled or even know if you're eligible for the surgery, you have to have a consultation with the surgeon. So it's not just one appointment, it's also the consultation and the surgery. And providers are booked out months in advance, right? They're really, really booked out far in advance. But a second part of it is the inability to kind of find providers, right? So timely access and network adequacy, the ability to get it within a certain time, and then finding a provider to provide it. Those are probably the two biggest issues that pop up in addition to medical necessity, which we'll get to next. Because of a lot of the fear on the national level, clinics have closed, right? Like Children's Hospital of LA has closed, which means all the surgeries that were scheduled are canceled. And then all of the other clinics that were performing surgeries for individuals 18 and under are no longer doing those. So there is, the limitation by just the availability of providers. So if a surgery is canceled, and the clinic closes, unfortunately, you'll have to find another provider to do it. Now, how do you find another provider, right? If there's so much fear going on and everyone's trying to kind of hide from the federal government in terms of not being targeted or, really putting a big spotlight that they're providing gender affirming care, We had advocated for years before this current administration for provider directories to be listed online, for the health plans to include them, for them to be accurate and up to date. But now with the attacks, not only on hospitals and hospital systems, but on gender affirming care providers, it can be a little bit harder to find providers. So our best recommendation is, if you're trying to find an in-network provider, is to call your health plan, and you can ask them for providers. With that being said, they may not be the most knowledgeable. So my recommendation is always to request a list of in-network providers in writing, not just over the phone. That way, if you're not able to provide a provider, if you're not able to find a provider, and you need to move forward with a grievance, that request can be used as evidence to prove that they don't have an adequate network, right? And when I say in-network provider, that means, when you have a health plan, part of the health plan is that you agree to go to the providers who are in network for that health plan, right? And you go to them first instead of just going to someone who doesn't contract with your health plan or take your health insurance. Now, with there being limited providers, it may be the fact that there's simply no providers in network that provide the service, right? So then you're thinking, okay, what happens in those instances? Well, just because a plan doesn't have a provider in network doesn't mean that they are, they get to throw their hands up and say, oh, well, we don't have to pay for the service anymore, right? Because in that instance, they wouldn't contract with any providers, and then they wouldn't have to pay any plans. So, they may not have providers. It's very frequently, for example, Molina here in San Diego County doesn't have any bottom surgeons in network, period, for Molina in San Diego County alone, right? So we know that we have to go out of network. Well, for a long time, Molina was playing games and say, no, we have people in network. We have surgeons in network. And we're saying, okay, who? We can't find them. And they're like, oh, well, go look over there, right? And then they would say, oh, go look over there. And they sent us on a wild goose chase. And we realized it was a strategy that the plans were using to create a barrier that you couldn't overcome. And then you didn't get the service and they didn't have to pay for it, right? So if you're ever experiencing that, what I recommend is file a grievance with the health plan. And I recommend filing a written grievance with the health plan that you can prove you sent to them. Because I cannot tell you how many times health plans will say that I don't know who you are. We've never talked to you. We've never received a phone call. You've never received a grievance. And that's even with coming with a letter to them, an acknowledgement letter of the grievance where they have provided a tracking number, right? And it's sent from them. So it is very different than corresponding with another attorney or opposing counsel. You are working with a health insurance company with underpaid, overworked, and high turnover staff, right? So they don't have a lot of institutional knowledge. They don't know the rules. A lot of the times they're dealing, if we're kind of explaining, Liza was explaining earlier how different rules apply to different plans. These individuals that are representatives for the health plans, they're not attorneys. So that intricacy or understanding different rules can be lost on them. So always document what you're doing, prove that you're sending the grievances or you're making those official requests. And then one other thing I have a tip for is one thing that I pretty much every single client gets very, very frustrated is they say, I have called the health plan repeatedly to try to address this. And I tell them, understood. Treat the phone calls with your health plan as informal communications, right? Just because they tell you something over the phone does not mean you can hold them to it, right? So if they say, oh, yes, this provider and this service is covered, and they only tell you over the phone, you can't hold them to it. If they send it in writing, it's a whole different story where you're saying, you send me written approval or, communications instead of just over the phone. I've had clients even record the conversations in secret and go to DMHC and file a complaint, and still, it wasn't in writing. So it didn't amend the benefits of the contract, right? So yeah, they're not your friends, to say it shortly. I also just want to point out, it's really important for individuals, if there are no providers available to provide the service, it doesn't really matter if it's a covered benefit, right? So if there are no providers, period, providing a specific surgery, the health plan can't pay for it. They can't cover the service. So if there are no providers, that doesn't really, it doesn't help because you can't pay for a provider that's non-existent, right? So obviously timely access and network adequacy is always tempered by what is actually possible in terms of how many providers are available. If you are struggling to find a provider and you're also struggling in network or with the health plan, right? You file a grievance, you still can't figure it out. I recommend going to a local LGBTQ plus community center or an LGBTQ plus run organization, because they usually keep lists of providers or information. So that's another helpful way if you're not able to find one with the plan's help. You still need to try to find it through the plan, but in the meantime, it can be helpful to seek out other LGBTQ plus community organizations. Next slide, please. Medical necessity and utilization management controls. These are also huge barriers that come up, and probably the most weaponized part of the insurance process used by health plans or health insurance companies to make money, right? And to deny claims, to not pay out money. So for medical necessity, they will deny it for medical necessity, but the reasons they are denying it for medical necessity may have nothing to do with the medical aspect at all. And the way I always frame it for clients is there's a difference between the prior authorization requirements to have it paid by your health plan, right, in one bucket, and then in the other bucket is your medical doctor's professional opinion on how to treat your condition, right? Those can be very confusing when the health plan keeps saying medical necessity, right? So the way I frame it for my clients is when I'm talking about medical necessity with the health plan for coverage purposes, I say think of it as a checklist. We're not talking about medicine. We're talking about a checklist of all of the documents you need to show to get it approved for coverage, right? For surgeries, a mental health support letter from a mental health provider is one of them, right? Another part of the checklist is to confirm that all of your other medical conditions are contained, right? So I've had one case only in my 6 years where it was an actual medical reason for denying it, and it was because of her blood pressure, and it was unsafe to do surgery, period, with her blood pressure at the rate it is, right? But a lot of the times, these denials from health plans, they'll be coded in a lot of medical language that becomes really confusing on what it is, right? So if you get one of these medical necessity denials, I would always stop and say, okay, what are we missing from the checklist, right? Did we attend the consultation before requesting approval for the surgery, right? Because you technically don't know if you're eligible for the surgery until you've had a consultation with the surgeon, right? Is it because they're just saying it's always cosmetic, which is an illegal in the state of California for state regulated plans? That's an illegal categorical or blanket exclusion, saying top surgery is always cosmetic, for example, right? That's not allowed. And that's also not a medical decision, that's a coverage decision. A lot of language that they used to use in notices, they've kind of dialed back, but I anticipate an increase of this language is talking about how the person already looks like their gender identity that they self-identify, right? Saying, oh, your chest already appears female enough, right? Or your face already appears female enough. Well, there's no way to measure what physical appearance goes with a gender identity, right? And that is not the appropriate standard to review these, right? That goes into a reconstructive standard, which is a whole other presentation for another day. But if the denial is speaking to how the person looks, you likely have some type of violation, right? And file a grievance. Now they can have administrative requirements, that checklist, that are, generally accepted standards of care, right? They can't do things that are, if it seems illegal or if you get a feeling that this isn't right, that's the time to look into it. And what do I mean by that? We had a client one time where I got a message from the doctor and saying, hey, this health plan is telling my patient that in order to get hair removal services on their face, they have to grow out a beard, even though they identify as female. They go to work as female. They are not out as a trans person. They have to grow a beard and take medical grade photos to prove it's medically necessary, right? And you're thinking, whoa, so then this person has to go out. Nobody at work knows there's trans, right? They have to out themselves. They have to present with a beard on their face. That's not appropriate, right? That's where you kind of, your red flags start shooting up like, whoa, is this really an appropriate prior authorization requirement, or is this an inappropriate kind of request to create another barrier to care? If you have questions, this is, we were talking about a very, very complex subject matter, not only within the medical realm, but the regulations. If you have questions about any of this strategy cases, please feel free to reach out, because, I blaze through it, I think in 15 minutes or a little bit more. And that's a lot to go through. So I also understand if you're like, I need follow up, definitely feel free to reach out. I'm more than happy to co-counsel or give case review or assistance, assuming you're not charging your clients, that is. And we're also to help to take the cases on as well. But I will pass it on to Liza for our last portion.
All right, next slide, please. Okay, so I'm just going to talk really quickly about how to find gender affirming care cases in non-health cases. I saw in the poll that a lot of folks don't currently have any gender affirming care cases, but obviously, as Abby talked, there's been so much going on in the world of gender affirming care, and there is, like Antonio said, a ton of panic in the trans community about what the future of gender affirming care access looks like for them. I've had a ton of doctors reaching out to me and saying, like, my patients are asking me if they should be rationing their hormones. What do I tell them? So there's a huge need for community education right now. And if you are, have capacity to put yourself out there to provide some of this community education, you will start to get these gender affirming care cases. There are a lot of them out there, but you kind of have to look for them a little bit. So if you don't currently have any, here are a few of my sort of tips for looking for them. One is if you do name or gender marker change petitions at your legal aid, this is a really good place to find gender affirming care cases. We do a lot of name and gender marker change petitions, and I always ask while I'm sitting there with the client doing their paperwork, I ask, are you able to access all of the gender affirming care that you need? And I would say over 90% of the time, the answer is no. But even though they are there sitting with me in my office doing their name change petition, they didn't raise to me on their own that they aren't able to access gender affirming care, right? But when I ask them, are you able to access all the gender affirming care you need? A lot of times the answer is no. And I say, okay, like what's going on? Is there something I can help you with? And then you are able to also open a gender affirming care case. If the answer is yes, if they say like, yeah, I'm getting everything I need, I also will ask them like, do you mind sharing with me like what providers you go to? Because it helps me to like keep an internal list of my own of who are the providers in my community who are good and people like, and they provide gender affirming care. So when I have another client who is looking for a provider, I'm like, oh, I know this provider does it, right? So it's kind of whether the answer is yes or no, it's a good question to ask. Housing and employment cases, if you do a lot of housing and employment cases, you might see like discrimination type cases, or if you have clients who are trans and they're experiencing housing or employment cases or issues, that you might see that those issues then also lead to disruptions in healthcare, right? So that is also a place where you might ask, like, are you able to access all the care you need, especially if someone has like lost employment. We saw, in the pandemic, as people were losing employment, they also lose access to healthcare coverage. And so they're often looking at transitioning either into Medi-Cal or a completely different network, or they're going to go uninsured for a while. And so they're looking for care. And so that's a place where you might ask and, be able to open a gender affirming care case. And then another place where we do often see gender affirming care issues is in education cases. We do get, families who are reaching out to us about like bullying issues for their trans kids. And that's another place to ask, like, are you getting all the gender affirming care access that you need? And I find with those cases, especially if they have a parent involved who is trying to make sure that they address like a bullying issue or a bathroom issue at school, those kids are often on private employer insurance, and that is where gender affirming care access is the trickiest right now. And because it's for youth, that is also like the subset of this community that is experiencing the most disruption in care. So it's just a place to ask. It's like doing the extra question in your intake that if you don't do it, you will miss these issues. But if you do, they will readily tell you like, no, I'm not, I'm paying out of pocket. And then you can tell them you shouldn't be paying out of pocket. Medi-Cal covers that, right? And so you can open the gender affirming care case then. So yeah, I think that's all I have. And I think we are open for questions now, right?
A couple more slides, if we
Oh,
can
okay.
do the next slide before we do questions. Okay, so just wanted to point out that we do have a list of resources in the PowerPoint, and there are also some additional resources that are part of the MCLE that you'll be sent. So please do take a look at those. They're really outstanding resources. And then I think next slide, please. Before we go into the Q&A, because we have time for about one question, I want to give a huge thanks to Antonio, Abby, and Liza, who I am so admiring of their ability to break this down in language that even a non-direct services lawyer like me can follow and understand. Thank you. And to LAC for hosting and facilitating this training. We're really thankful for your helping to put this on. On the last slide, I want to say is all of the panelists' email address and names, and we want to really encourage people to reach out to us. I think all of us are very committed to that. And I guess there was one question that came up in the chat that I know Abby gave an initial answer to, but I wanted to throw out to the other panelists as well. In light of all of these sort of patchwork of laws that apply differently in different situations, in thinking about advocacy for more expansive gender affirming care for people in California, what would you recommend? Would you recommend focusing on Medi-Cal recipients? Would you recommend a different focus? Abby put in the answer in the chat that California could set up state-funded clinics that provide gender-available care, gender-affirming care, and are available to anyone in California. So that's one example, or to extend Medi-Cal access to people enrolled in coverage programs that don't cover gender-affirming care. And I am just curious, anyone else have any other thoughts?
I again want to make a big plug for folks to like get out into community and do community education as much as possible. I think what I have found the most is there's so much misinformation, and insurance regulation is so complicated. People are, reading Reddit threads and reading stuff on social media. They're reading fact sheets that like national fact sheets put out by national orgs like the ACLU or Lambda Legal, and they just think like, oh, I no longer have gender affirming care coverage, right? And for a lot of people, that's not true. So for some people, it is, but being able to let people know like that is not the case. Let me give you some clarity, or even to your community partners so they can pass that along to community members. I think that is really important in this moment because a lot of people are making incorrect assumptions based on what they're seeing in the news and in the media.
And can we just put, in case anyone else has answers to these questions, can we put the resources slide back up while anyone else is giving answers? Thank you so much.
Yeah, I think my response would be, and maybe this is just the direct legal service provider in me, but I think the individual cases are really important for the bigger systemic advocacy because it provides the examples. It gives us an intricate understanding of what is happening, right? Because we were seeing a lot of, 5, 6 years ago, we were seeing a lot of denials, and Liza was so much more experienced than I was at that time. I was just kind of a newbie figuring it out, but we were seeing so many denials of medical necessity, right? And as we went through time and kind of figured it out, we realized a majority of them aren't medical based. They're kind of some confusing answer to make it seem like it's medical. So I think from my perspective, the individual casework is really important because with Medi-Cal, especially, it's regulated by so many state agencies that the data, if you have more grievances on these issues and that data shows up in the health plan, and then they can be, reprimanded for it or give the penalties or lose their contracts in future years if they're not performing appropriately. We were also we don't have sexual orientation and gender identity health disparity data in California, right? Medi-Cal plans, while they're putting out health disparity for other intersectionality and identities, they don't do it for the LGBTQ plus community. So we don't have data in the way that other civil rights engagements with regards to systemic changes do to show what we need to change, right? It's all through case examples and the individual cases. So I just see so much important in taking on the individual case. And even if it's just one, right, that provides such a great data point for us and for a lot of the support centers like Abby, who are looking at the data at a bigger picture for state agencies to perform more appropriately in regulating the plan. So that would be my response.
I just want to add also that like we've talked about how the legal protections in California are pretty robust, but the thing that really is impacting access to care the most right now is the disruption to the provider network. And so I think really what is important in this moment is resources for providers and protections for providers, because we've seen so many really strong allies of gender affirming care drop out of providing these services out of fear. And like Antonio says, like you can argue for insurance coverage all day, but it doesn't matter if there aren't any providers to provide the care that your client needs. And if providers are so threatened that they are not willing to provide the care, like there's not really anything you can do in terms of legal advocacy to get that care for your client if that provider no longer exists. And so I think the resources and protections for providers are really important in this moment to ensure ongoing access to care.
Thank you so much, everyone. And thank you so much for everyone who's attending. I'll turn it back to Jocelyn for a couple wrap-ups from LAC.
Thank you. Okay, thank you everyone for your time today, and thank you to the presenters. We hope to see you all at future training sessions. This webinar is eligible for 1 hour of elimination of bias MCLE credit. MCLE credits will be sent out to your registration email within 1 week, along with the recording of this webinar. Thank you, everyone.